on behalf of Northwest Landowners Association as an amicus. I'll also note the appearance of Keith Blackwell. Mr. Jorde, whenever you're ready, you can take the podium. Feel free to adjust that podium to a height that's comfortable for you. And then when you're ready, you can begin your argument.
Mr. Chief Justices, may it please the court. We're here on a very important issue that affects, obviously, our clients, but every single private property owner in the state of North Dakota. And that's because your Century Code 3215-06 allows a third party, whether it be the government or their delegee, to enter the property of any privately owned parcel in this state 24 hours a day, 7 days a week, 365 days a year, without limit to duration, frequency, where the invasion can take place, or what can happen, so long as it falls under survey, examination, or making maps. Pursuant to Loretto, which this court has cited favorably over the years and recently, as well as Cedar Point, which is invasion before it's a per se taking. Loretto was broadened by Cedar Point in 2021, and now we are informed that what was a permanent invasion, so long as it's an invasion of any time, duration, frequency, it is a per se taking, is unconstitutional. It's a per se invasion. It appropriates a landowner's right to exclude, which we know is one of the most, if not the most cherished rights of property ownership. So it's unconstitutional on its face for that reason. Background principles, this concept of background principles, background restrictions, pardon me. Summit Applee hopes that that saves the day, but there's several problems for that. Number one, in paragraph 29 of Summit's brief, they mention the Palazzolo case. Now, they don't cite it correctly, but it's an important case because it stands for the proposition that a statute alone, a mere enactment of law alone, is not enough to create a background principle. And why is that so important here? Because but for the existence of 3215-06, there is no right.
Didn't that right also exist at common law?
No, it didn't exist at common law, and pursuant to your statute 1-01-06, it says that any codified law, if there's a codified law in your Century Code, there is no common law. That's what it says.
You're asking for that statute to be unconstitutional on its face, which means it didn't exist, so wouldn't it revert back to the common law?
Well, yes, in that instance, if we go back in time to 1895 and now it's gone, then whatever the common law was, I'm saying, and my opponents haven't cited a single common law case that predates that would suggest that the common law allowed a third party to invade without notice, without compensation, and to have free reign over your property. In one of your decisions, I believe it was the Brocky decision, the district court judge there, in the first line of restrictions, said may not enter buildings. Now, how outrageous is that we leave it to the district court and put that pressure on them, like, yeah, guys, don't enter buildings. In this decision on summary judgment, the lower court has no restrictions. That means this law, if upheld, allows them to come into your living room on Christmas Day and drill a boring hole if that's part of the investigation that they want to do. No restrictions whatsoever. That can't be part of a background principle. You're correct. The second phrase mentions that, but it's very different than Article 116, Section 16 of the Constitution. They can enter without restriction. What possibly falls under willful or wanton, unless they're actually trying?
I would suggest that entering somebody's home would be.
But if the statute doesn't preclude that, then we're getting in a real gray area, because if there's no restriction on where the survey or examination can be done, then certainly they could go into a building, which is why the court in Brocky, or the district court in Brocky, specifically said no entry into buildings. If you have to say that, that suggests that the statute on its face is without limitation and is unconstitutional on that. That's correct. That's correct. That's what Loretto plus Cedar Point. If you appropriate the right to exclude, then unless it's a background principle, that's the only savior.
And your client's argument is there's not here.
Well, yes, and that's a good segue.
So that's why I want to make sure I understand. So your argument is, your client's argument is, in an absolute sense, there is no entry permitted for survey or inspection, period.
Well, unless it's a background principle, if I could take your inspection analysis, if the property owner has availed themselves, for instance, it's a restaurant, and you've availed yourself to the Health and Food Inspection Board, what have you, they can enter your property, your restaurant, and inspect without notice, and it's not under certain categories.
And I use the word inspection. I think the statutory term is examination. Is that right?
Yes, survey, examination, or maps.
And so in the context of survey of rural land, no entry, period.
Well, and I have to parse out rural land because the statute doesn't specify. So
That's our case.
It's our case here, but as a facial challenge, I think we look at the plain language of the statute, which doesn't say 100 miles from Bismarck, middle of nowhere, where my dad grew up, Plaza, North Dakota, Montreal County. If it's somewhere there, it's kind of like, what's the big deal? Like, really, you can't do a survey there? But the what's the big deal, and it's rural, goes to the balancing on the compensation determination. It no longer goes to, is this a taking? Because again, the Cedar Point broadening of Loretto, where permanency and intermittency no longer matter. So the Penn Central balancing test, when it's like investment back expectations, how bad is this? Is it 2 pints of soil? In a case you had here, the 2015 Brocky case on the soil borings, that balancing now goes to the just compensation that is due. And maybe it is Cedar Point said. And what's fascinating about Cedar Point is the statute that was on the books, well, actually, technically a regulation that was on the books there, was far less expansive than the statute here. So what the Supreme Court struck down there is a statute that said union organizers could enter the property of agricultural growers in Cedar Point, a strawberry nursery near Northern California. They were at the hour and the lunch break where no work or economic activity was happening, and they were at the hour after work was done. Now contrast this here. We have no temporal, no duration, no location limitations on 3215.06. So in that case, the investment-backed expectations, if we can kind of go there, it wasn't interfering with the work that had to be done, harvesting the strawberries. And so that was more reasonable, and the Supreme Court still struck that down. The location, they had specified locations. They couldn't wander out in the fields. They can't knock down a corn crop or sunflowers, soybeans, wheat, whatever you might be growing. They can't do the things that any government or any delegee that the legislature says should have the governmental powers, such as this particular proposed pipeline company. They could go anywhere and do anything. So Cedar Point, what that struck down was far more mild than what this statute really stands for. And the fact that in North Dakota you rely upon, or in some instances, a district judge, which I think is putting too much pressure on them personally, to save an unconstitutional statute and try to condition it away into something that seems less harmful and more reasonable, that doesn't make an unconstitutional statute constitutional. Just because a district court judge may put on reasonable expectations. And I don't know. The point is the power's there. And that's the problem for the folks, every private landowner in this state that could be affected by this statute. The power is there at any time, any place, anywhere.
Mr. Jorde, I want to ask a kind of a basic question here. Your clients have brought both a facial and as-applied challenge. We always resolve issues with least impact to a facial challenge.
Well,
if we find it unconstitutional as applied, why would we even have to go farther than that?
Well, you are the Supreme Court for a reason. You certainly wouldn't have to. What I'm suggesting here, even if you can resolve this on an as-applied, which in my opinion is just clearly unconstitutional on that basis, but what about the next landowner and the next landowner and the next landowner? This case puts forth the facts and the order below with no restrictions whatsoever. I get it from a practical standpoint, 100%. I'm a Nebraska guy, North Dakota family. I know how things try to get done, and I respect that. But there is enough legal basis to declare this unconstitutional for the arguments I made. I probably should talk a little bit more about background principles. The Palazzolo case again says a statute alone is not enough. If we, and that's at 2464 of the Palazzolo versus Rhode Island decision. If we have that as kind of a touchstone, and then we look at, well, hey, but what about common law? And then Century Code 1-01-06 says, well, if it's a statute, there's no common law. Then we go back to Justice McEver's question, well, okay, so go back to 1895, it's not there. Well, there's not a single case predating that suggests the authorized invasion by an unwanted third party against a landowner's will to conduct survey examinations anywhere, anytime, without restrictions, was a background restriction that the citizens of North Dakota would have expected was made their title servient to. No one would expect that.
Was that in the territorial code? This right of entry?
The 1895, I don't believe it was, and I think Mr. Broughton's going to specifically address that. I don't think it was.
There were citations, at least in the state's brief, to some territorial code. If it were in the territorial code prior to the state constitution being adopted, does that strengthen the argument that it was a background principle?
No, it's code, and that, say, territorial code, but for that, what else is there to make it a background principle? And when we contrast this against the three paragraphs, and the person, if a felon's fleeing across my front yard, knocks over my flower pot, but they get the bad guy, that's something that all North Dakotans, reasonable ones, would likely think, well, yeah, that's not a taking. I'm not going to get compensated. That is something that obviously is a part of our... Is that a taking? No. That's protecting the public from an imminent, emergent threat or danger. If we look at the examples given, they are nowhere near what Summit, what Applee is trying to do here. They're not in the same category.
Let me pause you there, because the right of eminent domain in our state constitution is limited to takings necessary to satisfy public use, right?
Correct.
So to determine whether a certain piece of property is necessary, don't you have to go do a survey to find the narrowest piece that the condemning authority needs?
No.
Doesn't that make it a background principle, the necessity principle?
No. And you're going to where I was headed. Is it a necessity or is it a convenience? And here's why. Title 32, Judicial Remedies, Chapter 3215, Eminent Domain, already has the procedure for this all laid out. The sky is not falling because all they have to do is simply get an access easement for the survey. So there's always a path. The statute that we're challenging is a convenient statute and not a statute of necessity.
So first condemn a temporary access easement to do the survey, and then...
What's the percentage of people that end up fighting a condemnation, taking it to trial? Well, it's less than 1%, okay? And so the practical reality is, whether it's this statute or they use the code that exists, the eminent domain laws, these aren't even going to rise to this level. But at least court in the world, how long, how often you legally describe the access easement. We can't go into your house, we can't go into your shed, we can't show up any time. Now think of the state like North Dakota where the castle doctrine is alive and well. And I don't want to put on a parade of horribles here, but my goodness, could you imagine a scenario where no person in possession is given notice under this statute? They don't have to tell anybody. This is not good law. And the eminent domain code already has the path laid out. So we know what's going on, we know where it is, maybe not like it, the landowner may not like it, but they're on the same page, and then there's a judicial determination. And maybe it's only $500, but at least that right, one of our most cherished rights, the right to exclude unwanted entry, was compensated, and there was due process. There wasn't any due process for the factual basis on the facts. Likely to say, okay, fine, we're going to work with you like they do in the high percentage of cases, then I would be patently unreasonable, in my opinion, because it's like, well, we're going to strike the statute down, and now there's the electric companies can't even get out there. This is craziness. But they have the path. It's embedded in the eminent domain. And it makes for better law, because if this is struck down and it's considered a per se taking, which it is, then what do the government and utilities and other folks do? They'll approach a landowner. Hey, this isn't going to be a really big deal. This is what we're going to do. They're going to have the dialogue. We're going to be here on Monday at 6. Is that okay? Okay. Hey, we'll pay you $500. What do you think? $200, whatever it is. And it'll actually be more streamlined. Think of this case. They filed the petition for entry on September 1st, 2022. We'll have a decision from you, I don't know, the first, second quarter of 2024. We're not saving any time here by saving the statute. We're actually spending more time than's necessary. We're frustrating people by not notifying them. We're taking away their right to just compensation. They're not any part of the process, and it must be stricken on its face and as applied. I see I'm running down on time.
You've described the district court's order and judgment as permanent several times. Is it sufficiently specific to record in the land records as an easement?
That's a great question. I don't know the answer, is the honest answer. If that judgment was recorded, would it be an easement? I think it probably would. It is a final judgment adjudicating all the rights, and it says that Appley has access 24/7. Well, it doesn't say that, but it pretends that 365. So yes, I think if that. I mean, I don't even think you have to file it because they'll just have it in a manila folder and show it to the landowners and be like, oh my gosh. But yes, I think that maybe is an easement on its face. I hadn't even considered that.
Unless it's vacated, Rule 60 or other relief later, it remains in effect, is your view?
Yes, thank you. It does. It remains in complete effect forever, which again, practically speaking, well, I mean, are they really going to come back in 99 years or 50 or 30? They can, without telling you, and they can go anywhere on your property and do anything they want under whatever examination, survey, or making maps is, whatever's convenient. This is a statute of convenience. These rights are so important, and if the right of the government to enter without notice, without due process, without payment, if that's so important, that right is so protected and cherished by them, then they can pay for it, and they can notice people if that right is so important. But in any event, they have a path so the sky isn't falling. They've got the path to do this. It's embedded in your law. And that provides notice and a fair path towards just compensation. So with that, I thank you, and I'll be back in rebuttal. Thanks.
Mr. Jorde, thank you for your initial argument this morning. Mr. Broughton, whenever you're ready, you can take the podium. Again, feel free to adjust that podium to a height that's comfortable for you, and then when you're ready, you can begin your argument.
Thank you, and good morning, Chief Justice Jensen, Justices of the Court, may it please the Court. I'd like to talk a little bit first about Cedar Point, and then I'd like to talk a little bit about the North Dakota Constitution and some specific North Dakota issues. For obvious reasons, I'm going to focus on the facial challenge here. But the first thing I wanted to say with respect to Cedar Point is that the justices in that case actually set out the background principles they were talking about, and they delineated them. And they were specific about that. And what I would point out is even the dissent in that case said, and I quote, "We defined a very narrow set of such background principles." They said what those background principles were. And they referred to the Lucas case. And in the Lucas case, what they were talking about is essentially nuisance law. But they were talking about principal property right. We don't include the right to maintain a nuisance on your property as part of your rights of ownership of that property. That's the kind of background principle that adheres in title to property. There are also a separate category, common law privileges to enter property. And they said traditional common law privileges are: one such privilege allowed individuals to enter property in the event of public or private necessity. The common law also recognized a privilege to enter property to effect an arrest or enforce the criminal law under certain circumstances. Just what are they? And he's referring to the background principles that they reference. And he says, we've said before that a government can, without paying compensation, impose a limitation on land that adheres in the title itself, in the restrictions that background principles of state's law of property and nuisance already place upon land ownership. But we defined a very narrow property of others, public or private necessity, enforce the criminal law, and reasonable searches. So those are the background restrictions that Cedar Point set out. It didn't say anything about survey access. But let's talk about 321506, because even putting aside Cedar Point, we also have issues here with the North Dakota Constitution because it is broader and it raises some additional issues beyond what they said in Cedar Point. And so there's been a discussion, obviously, in the briefing and here about background restrictions and whether or not what I just said about Cedar Point. And let's assume, just for the sake of argument, that maybe there is a background principle in North Dakota law or a common law right to enter. What is that right? What is that background principle? It's not defined by, the scope of that background principle is not delineated by a statute that was adopted from a uniform law, just like California's. There is a difference between an historic background principle of property law and a uniform law statute adopted by North Dakota. Those are not the same thing, and they've been conflated. As the appellant said in their brief, and I think this really nails it on the head, an examination in 1895 probably involved an afternoon with a surveyor and a mule. And that's right. The Land Ordinance of 1785, adopted 4 years before the United States Constitution, was the first instance where we started using land surveyors. From this statute, adopted from a uniform law. And what I'd say is the state itself to analyze these issues. What we have here is a treatise from Cooley that's been cited. That's it. And that, along with a lot of the arguments made, simply refers to survey access as this amorphous thing that means whatever's convenient in the instance of the argument being made.
Isn't this case a little different, though, because those Second Amendment cases were trying to figure out what a term was commonly understood to mean at a particular point in time? Here, Cedar Point and the Hennepin County case recently in the U.S. Supreme Court say that property law is defined by state law. And so that's not maybe as necessarily fixed in time. So aren't we, for your state claim, looking at what the folks in 1889 thought their property rights were when they were securing those with then Section 14?
In order to determine, for example, that a right to surveys, such as is anticipated by 321506, in order to say that that is allowed as a background principle as referenced in Cedar Point, it needs to be a background principle that existed and was known at the time of the adoption of the North Dakota Constitution, of the adoption of that statute.
So eminent domain was known to be a potential implication of owning property, right?
I agree with that, yes.
And that was limited to necessity.
Correct.
So how does the condemning authority determine what's necessary without an examination or a survey? That's what I'd like you to respond to as far as background principles.
In Justice Tufte, I would agree with Mr. Jorde that it is still possible to, in keeping with the necessity to bring a condemnation action to get that survey access. We have condemnation actions for temporary construction access, so that is possible. However, to your point, what I would say is that I think there's evidence in the record here and in general that there is a background principle related to land surveyors going onto a property to delineate the boundaries of a piece of property. And that's just because how else do we know what our property is or what property the government is going to take in your example? But that is a very different proposition than 321506. And the important point I want to get to here relates to the North Dakota Constitution, which is broader, and the most important way in which it's broader point. Because it's not.
Is there any history that North Dakota has applied our Constitution, even with the or damage language, in a more broad sense than the U.S. Constitution?
I don't know that I can cite a case from this court taking that language in a specific instance and applying it more broadly. This court has referred to that specific language and said that it is broader and creates more protection than the federal government. I also think that the Jacobson case very clearly explained why that language is important in this context. And they said, because when you're going on, you may be doing damage. And we require just compensation. And that's why, to your question, Justice Barr, I think that as applied versus facial challenge, there is part of this statute that must be struck down because facially it is always wrong for this reason. Because if there's damage, the measure is just compensation, because that's what the Constitution requires. Our statute says, and such entry constitutes no claim for relief, not even an inverse condemnation claim. No claim for relief conflicts with our Constitution in North Dakota that says when property is taken, as they discussed in Cedar Point, or damaged, as happens here. Now, if property is damaged, and I will say soil bores damage property, if property is damaged, it is not a question of whether there was negligence. It is a question of, was there damage? Yes, just compensation. That's what's required. And so in these cases, as the court in Jacobson said, even if there is a survey access, and even if we said, well, bring an inverse condemnation action if you don't like it, the problem remains. Just compensation has to be the measure of damages in that instance.
Mr. Broughton, your time has expired. Thank you for your argument this morning. Mr. Blackwell, whenever you're ready, you can take the podium. Again, feel free to adjust that podium to a height that's comfortable for you.
Chief Justice, may it please the court, my name is Keith Blackwell and I represent SCS or Summit, the petitioner in the proceedings below in the district court and the appellee in this court. I'd like to start by focusing on the statute. In Cedar Point, the United States Supreme Court recognized that while generally speaking, any government authorized physical invasion of private property amounts to a taking, there are exceptions to that rule. And one of the exceptions is a class of principles that are long-standing traditional background principles that may authorize a third party to have access to private property. And the court in Cedar Point said that when you have one of those long-standing background principles of law that provides a right of access, then the exercise of that privilege or right of access under the traditional long-standing legal principles is not a invasion that amounts to a taking and that requires just compensation for purposes of the Fifth Amendment Takings Clause. Now, the Supreme Court in Cedar Point pointed specifically to three traditional background principles. One of those was private necessity, one was public necessity, and one was the privilege of law enforcement officers to go onto private property when reasonably necessary to effectuate an arrest or to otherwise enforce the criminal laws. But there is nothing in Cedar Point that suggests that that list was meant to be exhaustive. And indeed, and I'm going to talk about the historical pedigree of the right of access for surveys and examinations in just a moment. But as we will see, when Justice Cooley and his treatise on torts discussed some of the common law privileges to access property, Justice Cooley discussed actually four. He put the right of a privilege that belongs to law enforcement.
Should we read anything into Cedar Point that did not adopt just
ground principles that would authorize an entry that would not amount to a compensable taking? But again, I don't think there's anything to indicate that the Supreme Court was trying to make an exhaustive enumeration in that case. So let's turn now to the historic pedigree, both in American law generally and in particular in North Dakota, of this right of access. The power of eminent domain, it has belonged to the sovereign since the beginning of the Republic. And certainly it has belonged to the state of North Dakota since statehood. The early cases, all the early American cases, recognize that as an incident of that power, there also belonged to the sovereign a right to go onto property, to inspect it, to survey it, because the exercise of that preliminary survey right was necessary to the exercise of the right of eminent domain.
Without limitation?
No, there is limitations under the statute. And this goes back to the facial challenge. I think the statute itself, when it speaks of surveys and examinations, is speaking of a limited right. I mean, the statute itself has to be read in the context in which the statute was enacted. And of course, this statute dates back to at least the Code of 1895 in North Dakota. The Attorney General has pointed in their brief to some territorial laws of the Dakota Territory that predated statehood, but certainly since the time of statehood, this has been the law. But there was additional context prior to North Dakota statehood. There are an abundance of cases, many of which are cited in our brief, that are early to mid-19th century cases from courts around the country discussing this right. And I think you can tease out from those cases in a general sense what the limitations are.
Mr. Black, I'm just going to interrupt you a second. Archaeological, environmental, geological, geotechnical, or whatever. Were those the same kind of surveys being done hundreds of years ago that would have included that right? Or is this a lot more expansive?
I don't know that it's actually more expansive. Certainly I don't think it's necessarily more invasive than what would have been permitted at common law. Certainly there are things that may be done today, like in the course of conducting a survey of property, being on the lookout for any endangered species or indications that the land at issue is a habitat for endangered species that wouldn't have been thought of 150 years ago.
Additional equipment taken on, or different additional damage to property, drilling, boring, or whatever? I mean, we don't have an explanation of what actually all these type of surveys, which is unlimited, and other surveys, we don't have any explanation as to what those consist of.
We certainly put in the record below, and the district court relied on a description of the kinds of survey activities that we were going to be engaged in, and they really were of two types. First, what we called a typical survey, and that would include both a typical civil survey, but also a typical environmental survey, a typical archaeological or cultural survey. And that involves a couple of things. That involves walking the land, observing the land, taking measurements, very, very traditional survey activities. It may also involve very minor earth disturbance with hand tools. Not with verified response to that. It was submitted as Exhibit 2 to our motion for summary judgment in the district court. It was before the district court. We described that in some instances, shovels or hand augers might be used to go as deep as 12 or 20 inches into the soil to check upon that minor disturbance of the soil would be immediately replaced. It would be immediately packed back in. A very small diameter borehole, 3 inches, that might go as deep as 100 feet. This court has previously indicated, and this was in the for obtaining soil samples, was within the scope of the statute.
That case was decided before Cedar Point.
It was decided before Cedar Point, but and I think this is very important to the facial challenge in particular. If the statute simply reflects a traditional background principle of law, then it is unaffected by Cedar Point, because Cedar Point does not change the law and make takings of the exercise of privileges to enter property that are supported and within the fair scope of traditional background principles. And I would submit to the court that as this court traditionally has construed the statute in Alliance Pipeline, in Square Butte, in the recent Cass County case, the Ayland case, I would submit that the court has construed the statute in a way that is perfectly consistent with the historical and traditional understanding of the right of access, because the court has required that the entry be innocuous. The court has required that the entry and the survey and the examination be minimally invasive. The court has required that it not seriously impair the owner's right to the use and enjoyment of the property, and it has to be temporary.
And none of those interests are protected here by the order.
Your Honor, with all due respect, I think they are, because the statute...
Are they stated in the order?
They are not stated explicitly in the order. And so let me turn to the final judgments themselves and the as-applied challenge. First,
Before you leave our discussion, we're talking about Cedar Point. What about the North Dakota Constitution that has that other phrase, or damaging?
it does. The North Dakota Constitution also explicitly makes damage for the public use compensable. And this statute, I think, does so because the statute explicitly requires that injuries, whether or not they are caused by negligence, whether they're caused with wantonness, whether they're caused with malice, that injuries to the property are compensable. And I think that is coextensive and consonant with the state constitutional requirement that there be compensation for damage.
Hypothetically, you're doing a 12 to 20 inch digging, whether it's with hand tools or whatever, you damage an archaeological piece of something worth thousands of dollars. Under the statute, there's no compensation for that because it wasn't through negligence, wasn't through malice. Am I understanding the statute right? That a landowner has no remedy?
I think first of all, if sufficient care were not being taken in the upturning of the soil, and as a result, there was damage, that it might well constitute an injury for negligence.
So if the landowner can go to court and prove you did not do it in whatever acceptable way there was.
I will say, Your Honor, my client committed from the very beginning that if there were any actual damages done in the course of these surveys or examinations, that we would pay the landowners.
But that's not in the court's order, correct? And that's not in the statute, right?
That's correct. That's correct.
Doesn't your interpretation of the statute simply wouldn't it make those words negligence, malice, and wanton superfluous? Why put them in? If they're not a restriction on when you can recover damages, why put them in?
I think, well, one reason to put it in would be because it covers the gamut of wrongful injuries wrongfully inflicted.
But it's a restriction on damages not in the Constitution, correct?
I think it substantially covers everything, but I think this court could construe the statute in a couple of ways. And if the court thought it necessary to preserve the constitutionality of the statute, to construe that language to require compensation for any actual and measurable damages, then I don't know that we would have a problem with that. Because, again, we've committed from the very beginning to pay for any damages done. So let me turn to the judgments in this case. And let me say first that I am not sure that an as-applied challenge to the constitutionality of the statute is properly before the court. In their counterclaim for declaratory relief, the landowners specifically said they were bringing a facial challenge. At the hearing on the motion for summary judgment, they specifically told the court, and they expressly told the court, we are not here on an as-applied challenge, we are here on a facial challenge. The district court looked at it as a facial challenge, so I'm not sure that a as-applied constitutional challenge is fairly before the court. That said, you also could view what might be considered an as-applied challenge to simply be an argument that the final judgments in this case were not, in fact, authorized by the statute, or not within the scope of the statute. And I would suggest to the court that it is true there are not explicit time, place, manner limitations, for instance. But there is also no showing in the record in this case that those sorts of restrictions would have been necessary. There's no evidence that we were likely to go out at 2 a.m. And enter upon land. Nothing in the record to suggest that we would do that.
Well, the briefing has recited instances where entry was made without notice, and that caused law enforcement to show up. I presume that that's in the record, but if not, at least we can guess that a lack of notice of entry into private land might cause conflict. Isn't that a problem? When we look at it through the lens of Cedar Point and the right to exclude?
As far as the record, I think that is in the record that was made on the motion to stay the judgment in the district court. It was made at that point after the summary judgment ruling had been made. There are a couple of instances in which there were claims made that, and testimony given through affidavit, that surveyors had shown up on the property. In several instances, it wasn't even clear whether those surveyors, in fact, were working for Summit or not, the ones that were talked about there. I will tell the court we make every effort to give notice, but that may not always...
but it's not in the order, so we can use that as our starting point.
Yes, it is not in the order, but I will also add, although a prospective condemnor has the option under Square Butte of coming to court and getting a judicial entry order prior to going upon the property, the statute does not require that, and in fact, the traditional privilege does not require that. I think that it would be perfectly lawful to simply, for a prospective condemnor to simply go out and survey the property. Now, obviously, there may be some practical problems with that. Obviously, that could invite some sort of confrontation that in very practical terms would be a bad thing. And so we want to actually encourage prospective condemnors to do what Summit did in this case, to go to court, to certainly give notice of an intent to survey the property through the judicial proceedings, and then to get a court order. But it is true that there was no notice requirement. I will say that in our petitions for a decree allowing us to go on the property, we specifically said that we would be amenable to doing so under whatever conditions the district court thought were appropriate. Ultimately, the district court exercised its discretion, and this court has recognized before in I believe it was the Square Butte case, that the statute does not specifically require, for instance, a bond. It does not specifically require conditions, but it certainly gives discretion to a district court to require a bond or to impose restrictions in its discretion. I would suggest that the record that was made at the time of summary judgment did not require an exercise of discretion in this instance to add those conditions. But if this court wanted to send the decrees back, thought it was appropriate to send the decrees back to the district court for reasonable conditions to be placed on the exercise of the privilege to go on and survey and examine, especially time, place, manner, or notice requirements, we wouldn't have any objection to that. Thank you very much.
Mr. Blackwell, thank you for your argument this morning. Mr. Axe, whenever you're ready, you can take the podium. As I've indicated before, feel free to adjust that podium to a height that's comfortable for you.
Mr. Chief Justice, and may it please the court, Phil Axt for the state. So much of the briefing in this case was about whether the district court's orders are minimally invasive or sufficiently tailored. The state is not a party to this lawsuit and takes no position on those specific issues. The state is only here to argue that when properly applied, the survey statute is not an unconstitutional taking and should not be facially struck down. To that end, the state would emphasize 3 points. First, a landowner's right to exclude or receive compensation is not absolute, and it never has been. 2, the survey statute reflects a long-standing background restriction on property rights. That's true in North Dakota, and it's also true around the country and throughout American history. And third, striking down the survey statute would have consequences beyond just this case. So first, a property owner's right to exclude or receive compensation is not absolute. This goes to the predicate question for a takings analysis, which is whether the plaintiffs allege a property interest that is constitutionally protected in the first place. And to answer this question, courts look to history and tradition. Or as the Supreme Court put it in Cedar Point, courts look to whether the public use being challenged reflects a long-standing background restriction on property rights. If there is a long-standing tradition of the challenged public use, then the landowner acquired title subject to that potential use, and it's not a taking when that tradition is simply exercised. And courts generally look to state law to determine what those traditions are, and those traditions may vary between states. For example, as Basin Electric's briefs points out, the high courts of Hawaii and Oregon have both recognized unique limitations on the right to exclude in their own states based on their own unique histories. In Hawaii, for example, the right to exclude is trumped by the public's right to gather resources from undeveloped land, and they've developed a body of case law for what undeveloped means in this context. And in Oregon, the right to exclude is trumped by the public's right to use certain dry sand parts of the beach. And in Cedar Point, the Supreme Court provided examples to illustrate that not all government-authorized physical entries on private property constitute a taking. It listed a couple which were discussed earlier: entry by law enforcement, entry to abate nuisances, entry for public or private necessity. So just as a general principle, not every government-authorized physical invasion of private property is a taking. Appellants?
Mr. Axe, accepting all that is true, but if they go on and then they damage property, is it a takings to prohibit the landowner from recovering? That's what, at least in part, the end of this section does. It limits the type of damages the landowner can get.
I have 2 answers for that, Justice Barr. The first one would be, is our takings clause was ratified at almost the identical time as the challenge statute was codified into law. And the fact that the statute was enacted at the same time the provision was ratified is strong evidence that the two were never intended to be in conflict. But additionally, and I'll get into some of the common law tradition around the country, I think it would be a reasonable conclusion for the court to reach that in order to read the statute constitutionally, it can bring in some common law principles for types of damages that would be recognized, and one would be damage to property. So, the appellants and their amici press a little too hard when they argue in absolute terms here that any government-authorized physical invasion is a taking. Cedar Point says that's not the case. You look to history and tradition to determine which government-authorized entries are a taking.
Mr. Axe, if I understand your position on the timing of the statute and the Constitution, is that saying that any statute that has existed since statehood that has never been challenged is automatically constitutional?
Not automatically, Your Honor, but I think if the constitutional provision has not had any substantive amendment, and here there's no allegation that our takings provision...
Have there been facial challenges to that statute before? Just because something hasn't been challenged before doesn't mean it's constitutional.
I believe there was a facial challenge in the INRI 2000 application case. I don't know if the court reached it. I can't recall off the top of my head. But you're correct, Your Honor. It's not a given that the fact that a long-standing statute has been in place for over 100 years means it's constitutional. But the state would say there's a strong presumption that goes with it if it's been in place that long, if it was enacted the same time or near in time to when the provision was ratified into the Constitution, that they were never intended to be in conflict.
What was Professor Cooley's What did he contribute to our state constitution?
So, your honors have actually addressed Professor Cooley's treatise a few times in other opinions, and you've recognized that his treatise was informative at the time of our Constitution's ratification, and it went into a lot of the rights that can be inferred into what our Constitution includes. So therefore, I think it's perhaps not correct to just dismiss Professor Cooley's treatise away as Northwest Landowners did. Professor Cooley's treatise, which we quote in our briefing, which I'll quote for your honors in some depth here, says, "No constitutional principle is violated by a statute which allows private property to be entered upon for the purpose of a survey and other incipient proceedings, and the party acting under this statutory authority would neither be bound to make compensation nor be liable to action of trespass." So I think that treatise says a lot about the state of the law at the time our takings clause was ratified into our Constitution.
Does that statement you just made imply that there's no need for time, place, manner, or other restrictions on the entry? They can be unlimited?
No, Your Honor. I think if you, and I can walk through some of the common law that the state would argue informed the state's decision in enacting the statute, but the tradition itself recognized that there were restrictions on what sort of survey access would be appropriate under a statute like this.
Well, the statute doesn't have any restrictions, and this order doesn't have any restrictions. So don't we ultimately have a constitutional problem?
Well, Your Honors have read a minimal invasiveness requirement into the statute to bring it into compliance with the takings clause, and the state would agree that that was a proper construction of the statute, just looking back at the history of the tradition for allowing survey access. So going back to that history, and it was suggested that there was no common law history of this, and the state would respectfully disagree with that. On this point, the state would point Your Honors to the Clement decision out of Virginia, which we cite in our brief, which thoroughly reviews the common law tradition. That decision notes, for example, a similar statute from Virginia as early as 1819, and that statute recognized limitations on the right to survey. It specifically carved out gardens, curtilages, homes from places that could be entered for conducting a survey. So going back to the early 1800s, it was recognized there were limitations on the right to conduct surveys under these sort of statutes.
Does the Virginia statute have a provision like North Dakota relating to ore damaging?
That I don't know off the top of my head, Your Honor.
Does that matter?
It may matter, but I don't know if it's dispositive, Your Honor. And going back to the Clement decision for just a minute, that decision also runs down decisions from the highest courts of New Jersey, New York, Massachusetts, as early as the 1830s, all recognizing this common law tradition, and all of them rejecting takings challenges to it brought under their own state constitutions. So it's long been part of our history, both at the national and the state levels, that a landowner's general right to exclude is subject to the public's right to survey the property for potential public use. Now, one of appellants' answer to that is that times have changed, surveys and exams could be more intrusive today than they were in 1895. And for that reason, they argue a statute that's been on the books for over 100 years should be struck down entirely, and it should be struck down entirely based on a constitutional provision that hasn't changed during that time, at least not in any way relevant to this dispute. But that's not how constitutional analysis works. Times change, technologies may change, but the application of constitutional principles to the new technologies remains the same. And that comes into effect when we talk about the minimal invasive requirement that this court has construed into the statute. And developments in technology might mean that some surveys or exams proposed today are not minimally invasive, and those surveys might indeed rise to the level of a taking. But changed technology does not mean it's become impossible for surveys or exams to be minimally invasive. And for that reason, appellant's facial challenge should be rejected. And just a third point, and see I'm running out of time, the state would just briefly note that striking down the survey statute could have wide-reaching consequences. We cite in our brief that this statute is used not just for making pipelines, but it's used for building and maintaining roads. It's used by irrigation districts. It's used for managing our water resources. It's used by the
Mr. Broughton argues that temporary easement solves all those problems. Why isn't that the answer?
Well, if I may respond, Your Honor, still running out of time. The state would say it wouldn't serve the public interest to require that all those entities go through formal eminent domain proceedings just to gather the data needed to evaluate whether eminent domain would be in the public interest in the first place. That's why this court said back in 1974 that to require eminent domain proceedings in this context could result in a useless act. That was Square Butte 1974. But more than that, invalidating the survey statute could be the detriment of state landowners, especially if it forces those acting in the public interest to exercise eminent domain over more land than is actually needed.
Mr. Axe, thank you for your argument this morning. Mr. Jorde, whenever you're ready, you can retake the podium and begin your rebuttal argument. You have 8 minutes reserved for rebuttal.
Thank you very much. So whose interest are we trying to protect? The Bill of Rights is there to protect the people from the government and not the other way around. And the way the statute here has been turned on its head, it's essentially anything the government may want to do in its discretion at any time. They don't have to tell you. They don't have to give you notice. They can go anywhere, anytime, and they can delegate that right to a private for-profit corporation, and there's nothing you can do about it. That's not protection from the government. That's an affront on our constitutional rights, our basic Bill of Rights. Now, I want to touch on a little bit on this idea of necessity. In the Lucas case, this concept kind of came up where Scalia argued that the state could always virtually justify any type of regulation that is necessary on any type of infinite range of ways where the public good may be compromised depending on the perspective of who's evaluating it. We're not here judging the importance or necessity of the underlying project. We're saying, is this statute something that is in any way constitutional? And the Loretto plus Cedar Point say no on its face. Their answers to background principles, and this isn't a dig at my opponents here, but they just don't have a good answer because it doesn't exist. They want to talk about other states. Full stop. We don't ever look at what any other state does when we're evaluating the background principle of a state. Palazzolo, Lucas are absolutely crystal clear. Nothing any other state does informs what happens in North Dakota in terms of what is the background principle of what the citizens of North Dakota believe is essentially a cloud on the title when they take ownership. And going back to that Palazzolo, I want to be very clear, and I'm quoting from it here at now 2464, quote, a law does not become a background principle for subsequent owners by enactment itself. All of our clients are subsequent owners. The fact that something was done in 1895 doesn't mean they can't challenge it, and it doesn't become a background principle alone. They needed more, in my opinion, respectfully, to convince you that the right to invade uncontrolled, unabated at any time on any property that's privately owned in this entire state is a background principle. It's simply not. And we look at the citizens' understanding. There is evidence in the record starting at declaration or index number 188 going through 200 of our clients where in paragraph 6 of their declarations they said they never thought a company like this could come on to their properties and at will go wherever they wanted to do any type of archaeological digs, etc. So that evidence is in the record. And in the summary judgment order, the lower court stated that it relied on that evidence. I guess that would be the only evidence in the whole case that goes to the fact of what do the citizens understand as a background restriction. So we win on that standpoint as well. And again, it's derived from the state's legal tradition, so we don't even have to get to what any other state may or may have done or what some other statute that doesn't matter says. Also importantly, back to our exchange, Justice Tufte, the state has quick take, meaning all the state has to do is we want to take this access easement and we're tendering $500, whatever it is, into court. They can be out there the next day. So this, to Mr. Axe's argument, I'm sorry, but it falls flat. The state can always come out and do this at any time by simply getting the access, simply petitioning for an access easement, putting the money into court later that afternoon, they can be out there accessing it. This isn't going to slow anything down if you strike the statute wholesale. Okay, as applied, sorry for jumping around, as applied to the borehole and the Brocky, INRI 2015 Brocky, in this instance, specifically in the order, it says they can backfill with cement. Backfilling with a foreign substance coming from off-site their boreholes on landowners' property is a per se permanent, forever taking, changing the nature of that ground. Absolutely a stone cold winner on as applied if you didn't like anything else that we've talked about today. It says cement/bentonite clay mixture. If they can bring in a foreign substance, and I take it under a grandfather who has a sunflower farm here in Barnes County, you don't grow very good sunflowers in cement. It's a permanent physical taking, it's an invasion, it's a per se taking.
Isn't that required to protect the groundwater?
No, cement is not. It could be refilled with exactly what they took out, but apparently cement is probably cheaper, easier to do. I don't know, but that's what the order says. I mentioned quick take. Okay, well, the as applied, if there's any questions that we didn't raise as applied, please bring them up. We addressed that on page 9 of our reply brief. Our statement of issues, second, I believe, covered that. Rather than going through 20 issues, we tried to combine them in our second issue. The opponents put it up as one of their issues in the case, so I think as applied is clearly before you. The Clement case, as what other states do, first of all, it's not a Supreme Court case, and again, we don't look at what other cases do. The background principles, they haven't come up with any example from Cedar Point or Lucas or Palazzolo that suggests this is anything similar to what a background principle is intended to be. This isn't an imminent public danger. We're not chasing a fleeing felon. We're not protecting the community from a flood that's going to take out the whole downtown. It's simply a convenience for private business and the government to take what they don't have the right to take without just compensation. Your Constitution is much better, if I can say that, than even the Fifth Amendment, taken or damaged for public use without just compensation having first been made. So unless it's the government, they need to first pay compensation on the front end. We have the Title 32 and 3215 that lay out all the ways to do it. It's well known. District court judges are all very familiar with how condemnation works in this case. It's been working forever. I would be curious to know how many condemnation cases the state has had to file in the last year. Is it 500 or is it closer to 1 or 2? The fact of the matter is, when we infuse some discipline in this process by striking down an unconstitutional statute, what we have done is made the public respect our laws more, because now they at least have to be on notice. They have a say-so to show up in court if they don't voluntarily agree on the front end, which most people do when they come seeking an easement, but they have the right to be heard. And that's what my clients as North Dakotans want. We want to be heard. Yes, we have the right to say yes or no, but my goodness, give us our day in court if we can't agree when you're appropriating my right to exclude, which is one of the most cherished property rights. Our request respectfully of you is to strike down the statute, remand back to the district court for findings consistent with your order, and also remand for a finding of fees and expenses, so at least the North Dakotans that were impacted, unfortunately, by this whole proceeding, they didn't get compensated for the right to enter that was taken from them or the use or occupation, but at least they could maybe be reimbursed for some of the costs of these legal proceedings. Thank you for your consideration.
Mr. Jorde, thank you for your initial argument as well as your rebuttal this morning. Council, thank you all for your arguments this morning. This case will be taken under advisement, as all cases are. This court will be adjourned until 10:45 a.m. this morning.